We have lawyers who specialize in construction law, labor and employment, real estate, environmental. So, you know, we don't dabble, and what we find is that makes us more efficient. And if you need advice in a certain area, we can connect you with the person who has the right expertise. So, my own involvement with ABC goes back about 25 years. In fact, Judd's dad, Ed Tanzine, when I was a young lawyer, said, you know, you should come to ABC meetings. You know, it's an organization you'd like to be involved with. And so I started working with Tancor and a lot of ABC members. My best, the story will make sense when I'm done, believe me. One of my favorite Ed Tanzini stories is I still call it the New Dow Credit Union, you know, the building over on Lyon. It's probably 25 years old now. But Tancor was doing the masonry work on that project. The general was from out of town. I can't remember who it was, but you know, some big company from out of town is going to come to Midland and show everybody how it's done. And they were slow paying, and so Ed gets struck and drives over, stands right outside the general's trailer. And I can't remember if they called Joanne or they called Judd, but they called and said, yeah, like, hey, your dad's like standing like outside his truck, like in front of the trailer. Well, yeah, he came over to get a check. They said, well, what are we supposed to do? And the answer was, well, you probably ought to give him a check. and he got a check. And so I asked him about it later. I'm like, did you really just go like stand outside the trailer until you got paid? He said, yeah. But I took a lien waiver with me. So I told him, as soon as you give me a check, you get your lien waiver. So it was a little construction lien clinic there. That's not going to work for everybody. You know, he was one of a kind. And so for the rest of us, we thought we'd give you a little presentation on construction liens and how to protect your right to a lien on a project. Get the shadow out of it. And Emily and Katherine are going to talk a little bit more about that. For my part, I've been in the Midland legal community for 33 years now. I'm a litigator. I go to court. I handle construction disputes, real estate disputes, things of that nature. I did for a little over 6 years. Had the privilege of serving as a Midland County Circuit Judge, so I kind of know the landscape and the lay of the land in the area, and courts and governments around the Great Lakes Bay region. And we opened our office here in Midland back in 2013. I've been with Warner ever since. So I'll give Emily and Katherine and DeAndre a chance to introduce themselves here in the next couple of slides, and then Emily and Katherine are going to talk about construction.
Thanks, John.
Thanks for letting us speak here.
Yeah, thanks so much for having us. We're really happy to come here and talk about liens, which are the most exciting topic for everybody, right? My name's Emily Rucker. I am the co-chair of our construction industry group at Warner. So we represent every type of participant in the construction industry. We represent general, subs, material suppliers, design professionals. I do exclusively litigation and dispute resolution. So as I was saying before, a lot of people say, you know, Emily, it's really nice working with you, and I hope I never see you again. So that happens sometimes. But we're going to talk today about how to best position yourself in the event that you do have a dispute. So hopefully you could talk to me very little. And I'll let Katherine introduce herself.
Hi, good morning. I'm Katherine Boothroyd. I work with John and Emily on construction litigation matters. When I started at Warner just a few years ago, I had never worked on any construction litigation cases before. And so I had the privilege of learning all of this from scratch, kind of trial by fire, but from a lawyer's perspective. And so hopefully that will give me some interesting insights if you have any questions today.
And this is our construction lien presentation, so I don't have DeAndre on here. So DeAndre, if you want to introduce yourself.
Sure. Yeah, my name is DeAndre Harris. I'm a partner in our labor and employment practice group at the firm, practicing out of Grand Rapids. I'm going to have fun with you later after we talk about construction liens, but I'm happy to be with you out there.
I'm going to stand up because I've got a little obstructed line of sight over here, and I don't want to not be able to make eye contact with anybody. So we'll start by giving an overview of the Michigan Construction Lien Act. It secures payment for labor materials for those who improve real property. And if that sounds broad, that's because it is broad. It can be pretty much any improvement to real property, and we'll talk a little bit more about that later. But it does this by granting certain categories of construction industry participants lien rights in the real. It is limited to private projects. Public projects typically have bonding requirements, which are similar but a little different to a construction lien. But you can't lien a government project because the government is immune from that type of lawsuit and that type of interest being created in that. The Construction Lien Act creates rights and responsibilities that are outside of your contract. So even if you have a very bare bones agreement, even if you just have maybe a purchase order and an invoice or an oral agreement, you will still have rights under the Construction Lien Act. And you still need to be cognizant of the consequences of the act. The Construction Lien Act is what we call a remedial statute. And what does that mean? It means it's construed liberally, except for a certain few provisions, which we will talk about a number of times over and over again today. But typically, except for those few provisions, if you substantially comply with the Construction Lien Act, which means if you do things mostly right in a way that satisfies the purpose of the various provisions of the act, you will be deemed to have complied to the with the act. So it's important to remember that and also those exceptions.
Just gonna add all the things that Emily is going to talk about today, the things that we talk about in detail, really think of that. Those are all the exceptions. Those are primarily the exceptions, and think of it as a checklist where every single box has to be checked.
And also this should be a conversation. So if you guys have questions, please jump in. Feel free to interrupt me and we can address them as we go. So first of all, who is entitled to a lien? Oh, history of the Mechanics Lien Act. I must have my notes from an old presentation where I took this out. So this goes way, way, way back. Most states have some sort of mechanics lien or construction lien type of act. It goes way back to the founding of our country, to Thomas Jefferson and to James Madison. And so that concept has been present in Michigan law since we were a territory, since before we were a state. Not the present Construction Lien Act, but the idea. The fundamental idea is allowing an owner of real property to use that property as security to improve it. So if you don't have great credit, but you have property, you have that land available to grant a security and to promote development.
Also, the Michigan Act that we have now comes from 1980, and before that, there were a lot of different statutes, and they were kind of inconsistent. And so what we have now is one, and you can see that it's very balanced and very detailed, and that's all on purpose because it was intentionally designed to promote clarity, to fix the confusion, and to balance the rights of homeowners and contractors and subcontractors.
And it works pretty well. It's not perfect, but I will say as statutory schemes go, it is pretty coherent. So who is entitled to a lien? Contractors, and the statute uses contractors to mean essentially general contractors or those who contract directly with the owner. Subcontractors, including subcontractors and material suppliers that contract with a contractor or the general contractor. And then also laborers, people that work on your projects. And design professionals are also included. They're subject to some specific rules I don't think we're going to get into today, but they also have lien rights. Your state licensed architect and engineers, not interior designers, as we have advised people from time to time. And so any of those parties who provide an improvement to real property.
One of the things Emily mentioned earlier is you don't necessarily have to have a written contract. There is one exception for that. For the general contractor for a residential structure does need to have a written contract. And also for residential properties, you need to have all of the licensing in order. Otherwise, you also will not be able to have a lien on the property.
And you can't get sued to get paid. So what is an improvement to real property? And I touched on this a little bit earlier. That is interpreted extremely broadly. It can include work from the very early part of the project, surveying, that engineering and architectural planning by the design professionals, pre-construction activities, clearing, demolition, excavation, all of those kind of early groundworks, all the way through finishing touches, landscaping, paving, and all of those things that come at the end of the project. It also includes, I thought this was interesting. A couple of years ago, there was a case about the installation of robotics equipment in an automotive plant, and that was deemed to be under the Construction Lien Act. So anytime you're affixing something to real property, that is considered construction or an improvement to real property under the act.
And I would say improvement for me that I wouldn't have necessarily thought before getting into this, that, demolition or excavation was an improvement. But it's really about, like visibility. So that is ultimately going to be an improvement to the property. But think something like paperwork or getting permits, like that's not visible. So that's not an improvement to the property under the act.
Yeah, and that becomes important when we talk about when the first improvement to the property was made, which can determine the priority of liens, which we'll talk about a little bit later. So we'll just give an overview of the lien process. First comes the notice of commencement, then the notice of furnishing, your sworn statements, then hopefully you get paid, but you may be calling us and not getting paid. Then your claim of lien and the lien foreclosure process. So we'll talk about each one of these in turn. So the notice of commencement is the responsibility of the owner to a project. The owner or the lessee that's contracting for the improvement with the general contractor records a notice of commencement in the register with the Register of Deeds in the county where the project is taking place. And they're also supposed to post it in a conspicuous place, usually at the job site, if there's a trailer in the construction trailer, before any actual physical improvement begins. And what Kat mentioned, the key to actual physical improvement is doing something that if you drove by, you would see that there's a project happening there. So it could be demolition, it could be excavating, something that would put somebody on notice if they were nearby of a project. The notice is on a statutory form, and that's the nice thing about the Construction Lien Act. A lot of the things that you need to do, they have the language right in the statute. So it's specific. You can look up and find the exact words you need to do. This actual physical improvement doesn't include surveying, soil boring or testing, architectural engineering planning, or delivery of supplies. And again, that doesn't mean that you aren't entitled to a lien for those services, for the surveying or delivery of supplies, but it's not counted as the actual physical improvement for the start date of the project. Does that make sense? And then it's the owner's responsibility to file the notice of commencement. It's important for a subcontractor to know that if the owner doesn't file the notice of commencement, that affects the subcontractor's rights. And it's pretty frequent if you are maybe doing a one-off job for someone who is not experienced in managing construction projects. I think you'll find fairly frequently that there's no notice of commencement. For example, I had one that was, they were painting a plant, an automotive manufacturing facility, which is kind of it's construction, but you kind of think of it as a maintenance item, and the people managing it were just the purchasing folks at the automotive manufacturer, and they don't know anything about construction, so this was not on their radar at all. They didn't file a notice of commencement, so that means that the subcontractor could file an what would otherwise be a prohibited lien, and led to some exposure. So it does affect your rights.
See, it sounds boring, but like Emily said, it drives a lot of downstream risk, and you can think of it kind of as a roster. It just has all the information that you need. And so for the next steps that we're gonna talk about, the notice of furnishing, it's really important that you do have that correct information. So if you've not been provided one, you can ask for one. So make sure that all the information that you need for your next steps and your duties and responsibilities is correct.
Yep, and it contains all this information. It's basically lays out everything that you need to file a lien. So it includes the legal description of the property, so the general contractor or subcontractor doesn't have to dig up that information. In the event of non-payment, it identifies who the owner is, so you know who you have to serve with that lien. And then, you know, how people are to get notice, what address you should send things to. And it also has, again, some statutory form language about how to file a lien and the existence of lien rights. And it should include a blank notice of furnishing, which is what we're gonna talk about next. So this is a document created and submitted by anyone who doesn't have a direct contract with the owner. So it can be a subcontractors, it can be a supplier, it can be laborers, anybody that is not contracting directly with the owner. And that makes sense because the purpose of this notice is to tell the owner, hey, I'm working on this project and you need to make sure I get paid. When you're looking through your documentation, your payment applications, I'm somebody that you need to look out for to make sure I'm paid. Otherwise, I may exercise my lien rights. The subcontractor or a supplier is supposed to provide this notice within 20 days after first furnishing labor and material. Again, there's a statutory form for this. It should be attached to the notice of commencement. Basically says, hey, this is who I am. Make sure I get paid. It's very short. Laborers are supposed to provide this notice within 30 days after payment was due, so they have a little bit more leeway than the subcontractor. It's important to note that if you're a subcontractor and you didn't file a notice of furnishing, there still may be hope because constructive notice can sometimes be enough. If you had direct contact with the owner early in the project, if it was very apparent that you were on site, if you had trucks with your logo on it, if the owner has some reason to know that you were there and that they should be on the lookout for you getting paid, like don't stop yourself from calling your attorney to do that because there may be enough there to excuse the notice of furnishing requirement.
I would just say normalize notice of furnishings. Most of the litigation cases I've been on, there isn't one, and it just makes litigation messier. And when litigation gets messy, it gets expensive. It's not about, expecting trouble. It's about protecting your rights. Think of it as checking in at the job site. When you get there, you check in so that the law will recognize all the work that you do after that.
Yeah, go ahead.
As a supplier, we deliver to homes throughout the state, everyday roofing, siding, windows, that type of stuff. Should we be putting a notice of first to every home that we go to?
I think it's a good practice. It's a good practice to protect your rights.
Okay.
It's always a judgment call on whether the administrative burden for your business makes sense versus the amount of your job. But it's an easy step you can take to eliminate your risk. Especially if it's a home reno project. I don't know whether you do primarily new builds or renos.
Usually renovation.
Yeah, so I mean, the owner might not file a notice of commencement for a reno if they're not financing it and they don't have anybody in their ear telling them like, hey, you need to do this. So, you may be excused, but it's the burden on sending one out. It's a good practice.
Okay. It is just a one-page document. If you have the form language, you are maybe just have highlighted the parts that you have to switch out, like the address or, all of that information. And suppliers, I think, can be especially at risk of this because a single delivery, 20 days from that, it can go by really quickly.
Yeah.
So the burden is not too much. It just protects you every time. And then you're always protected by changing a few paragraphs in a one-page document.
Yeah, and you don't need the legal description for the notice of furnishing. So that eliminates some of the burden that you have when you file a lien to dig that up and get it right.
We have some clients who just, as a business matter, say, if I send out a notice of furnishing on every job, and it depends on what trade you're in or what you're supplying. Are you doing a lot of high volume stuff? Are you doing fewer jobs or fewer projects with higher dollar amounts? they kind of set we have clients that just set an internal threshold for like, if it's over X amount of money, we're gonna do one, cause otherwise we'd be doing them like all day long. We'd have to hire somebody to just do notices of furnishing. And some businesses are high enough value that it makes sense to do that. But, you know, every business is gonna vary a little bit, so you may wanna have like an internal protocol for, you know, if it's over this dollar amount, we're gonna do one, or, and sometimes, look, if you're working with the same, you know, the same subs, it's an owner you've worked with before, you know, in your situation, that's obviously not the case, but, you know, it's gonna vary from business to business. But, you know, as Emily and Katherine have said, if you get into litigation, it's gonna make it a lot messier if you didn't serve one, so.
And I like Katherine's point of normalize it, because a lot of our clients say, you know, I don't do any of this. I don't participate in the scheme. I work with people, and if they don't pay me, then I'm not going to work with them again. Which is fine, unless that job that they didn't pay you for is big and it can significantly jeopardize your business. So sworn statements, I'm sure most of you are familiar with these. This is provided to the owner or the lessee by the general contractor, or also by subcontractors to the general contractors upon request. It has to list every subcontractor and supplier with whom the general has contracted, plus any laborers who are owed money and payments made to date. Again, there's a statutory form for this as well. It needs to be provided when payment is due to the general contractor. When you're applying for payment, when you're requesting payment from the owner, or whenever the owner or lessee requests one. So you do have a duty to provide it upon that request. It also has to be in before a lien foreclosure action, and that's an important one. A lot of times, you know, if you have a job where you're not doing sworn statements as a matter of practice, if it's a smaller job, more informal contractual relationship, you won't have done one. So sometimes we attach it to the complaint to say, here's your sworn statement. It's important that these are accurate, and Kat will tell you why.
Yeah, you can start to get, you'll start to see that, I call it the double payment problem. And we've had, you see in the act how it's balanced between the homeowner's rights and the contractor, the subcontractor. So you can have a situation where maybe a contractor is saying that he has paid a subcontractor when that's not true. And the homeowner makes the payment. Now what do? Now we're in a pickle because the act doesn't want the homeowner to pay twice, but the subcontractor actually hasn't been paid. And in those situations, usually, you know, somebody's doing something illegal and there are criminal penalties for a false sworn statement. They might leave town, there's no money. Now everybody's fighting and it's really expensive to go to litigation. So all of the things, all of the steps, they all kind of fit together. If you have that notice of furnishing, that's going to help you in that situation, because then maybe it's the homeowner's job to look and see if you were actually paid. They're supposed to, we're going to talk about also the lien waivers. That's supposed to also, you know, play a role and be part of it to make sure everybody gets paid. But the whole act is set up that way so that it's all balanced. And if you start missing these steps and these checks from the checklist, you're going to get yourself into a corner.
And the penalties for knowingly signing a false sworn statement escalate the higher it gets. So it can be up to a felony punishable by 10 years in prison, or a fine of up to $15,000 if it's over $20,000. So I'm sure I don't have to tell anybody in this room to not do it. And, you know, keep an eye on your paperwork to make sure nobody you're working with is doing it either. Payment. Hopefully this happens. Hopefully this is the most important part. But there is a situation where if there's amounts owing on the sworn statement owed to subs, owed to suppliers or laborers, the owner of or the lessee is entitled to withhold that and pay directly. You know, usually this doesn't happen if you're having a working contractual relationship, but when things start to break down, sometimes it does. There are notice requirements. The owner can't just go and pay subs without notifying the general, but it is a right that the owner has.
And here again, we'll see some of the balance and an exception for residential structures. You think of like an owner of just a residential property, they get additional protections under the act. And so there's another exception where the owner of a residential structure signs an affidavit saying that they paid the subcontractor, then the lien doesn't attach. And so that's why all of the steps are really important, so that, you know, going back, the owner had notice, you know, whether or not the sub was paid. But for residential, always, I would say, be extra aware that the homeowner does get additional protection.
Yeah, and I've done that, not even on behalf of a homeowner before, but on behalf of their bank, because if they have a construction loan and their bank is keeping a close eye on everything, they should be able to catch that. Lien waivers, so if you show up to get paid, you wanna, you know, bring this with you. Oh, I love it. So this is often required as part of the payment application process. There are 4 kinds of waivers, and this is easy because they really are what they sound like. There's partial conditional. So when you are applying for a payment, you can say, if I get paid X number of dollars, I will waive my lien in this number of dollars. Partial unconditional is after a progress payment. So I have been paid X number of dollars. I unconditionally waive my lien rights in this number of dollars. Final conditional, when you make your final payment application or your final payment is due, you know, basically if I get paid this amount, I waive all my lien rights, we're done with the project, everything is good. And final unconditional is after every dollar has been paid. Just make sure that you're signing the right types of waivers. You don't want to do a unconditional when you're meaning to do a conditional. If you are dealing with a contentious relationship, sometimes people demand the wrong types of waivers. They might demand an unconditional when really they should be getting a conditional. So just be careful about that language, review them carefully, make sure you're using the right one for the right situation.
Don't sign it unconditional until the money is in your bank account.
Yeah. Yes.
And I would say one thing I have realized sometimes is for commercial projects where they're, you know, building something to sell immediately, that can actually, you know, that could be leverage as well. If they need all the lien waivers immediately, you can make sure that you get paid quickly so that they can go ahead and sell the project on.
Yeah.
I have a question. As a commercial contractor, suppliers oftentimes, if it's not a big enough job, now it can be, you know, tens of thousands of dollars, but we've had owners that want lien waivers from a supplier that we have either open accounts with or have paid by credit card for certain items that were part of the project. I'm never gonna get a lien waiver with an open account when we're buying little stuff. Have you ever seen a way to resolve that, or is there an issue? Paid receipts, I mean, that's really a lot of work.
Yeah, you mean like little stuff like.
Yeah,
run
they
out
go
and
by a little bit, a lot of times, you know, we don't include it on the lien waiver, but if it's, and we're a mason contractor, so we go and buy enough block at Lowe's, Home Depot, Menards, you know, the local big box store. And you take them there, you do it's a dumpster enclosure.
Yeah.
Something like that, and they're like, well, we need a waiver from Lowe's. It becomes a real issue.
I have seen waivers from Lowe's and Home Depot before. I don't know how they
We
get
do.
them. honestly.
We do
Yeah.
get them on project specific.
Is you are going to the store, sending somebody to pick up block.
Yep.
Then it's in your inventory, right?
Correct.
Take it back to your yard. Then
And then you
I would
purchase-
tell the owner, look, that's my inventory. So you're getting a waiver from me. And I'm selling you my labor and materials, that's my
So
material.
don't put Lowe's on the sworn
So you don't
statement.
put Lowe's on the sworn statement, because if you don't, you know, Lowe's has already been paid.
Mhm.
Lowe's does not have lien rights on the project because they're supplying to you, you now own the material that you're holding in inventory.
There's other specialty
So-
items that we order
Yeah, exactly, now, right.
and have to pay by credit card in order to get them shipped and things like that. So it never really is allotted or assigned to the job.
That's just it.
So keep 'em off the sworn
Specific to
statement.
The project.
Yeah, and that's actually laid out in the statute that if you're supplying goods from your own inventory, then it's not required to be on the sworn statement.
And once you pay for it, it's not your property anyway, so it is yours, so it's not like you're expected to get paid and pay somebody else for that anyway.
Right.
Oftentimes the people asking for the waivers aren't really familiar They're
Yeah.
just checking a box.
Don't list anything in your form statement that you don't expect to get a waiver from, so.
Boy, we're gonna have a lot of inventory then.
Rip my-
Yeah, I had a question on, like, final unconditional after payment there. If they just take a picture of the check and put it in with the unconditional waiver, is that a big deal? Is that still showing proof that we are getting paid with the check being in there, or no?
No, I would wait.
Okay, and
Get
what
the
if
check
they,
in your hands and
Because
put it
they
in your
stop
bank.
payment on the check.
Yeah,
And it does happen. I mean, they said, hey, here's the check, here's a picture of it. I'm like, sweet.
people do that all the time.
You get the check and they've stopped
for
payment.
sure, yeah,
I haven't been paid.
I didn't know if that was like a proof of showing that they said, yeah. okay.
Yeah, so I provide a final conditional in that circumstance.
Okay.
Yeah.
Alright,
What if you can't get an unconditional from a subcontractor? Let's say you have a dispute over a change order, you don't think you owe the subcontractor, you paid him his full contract amount, but he refuses to sign an unconditional waiver.
Yeah, I mean, that's a tough situation. That's when you have to negotiate and see if there's some workaround that the sub would accept. We'll talk about bond rights.
Yeah.
A little later, and a lot of times that's the answer. If you can get a lien replacement bond or something like that, that is a substitute for the subcontractor's bond rights or lien rights, but still provide security for payment. That's probably the most common option we see if the dispute is looking like it's really not gonna be able to be worked out, but it does provide powerful leverage for the subs. Yeah.
Your stamp.
Okay, so now we're gonna talk a little bit about perfecting a lien and then the lien foreclosure process. So say you completed your work, you haven't been paid, you're thinking it's time to file a lien. Please don't call us on day 89. Because, contrary to popular belief, we are lawyers and we're not magicians. So sometimes we need to find information, we need to identify the legal description, we need to make sure that everybody that needs to be served is being served. And we can do that pretty reasonably fast, but we might be out of town or, just please don't call us on day 89. Try to anticipate. You might even set like a policy, like if you haven't been paid by X date, you're at least gonna call your attorney or set in motion your lien perfection process. So we're not doing a last minute rush so it needs to be within 90 days of last furnishing labor or materials. And that 90-day deadline is one of those deadlines that is not subject to the substantial compliance standard. It is, you do it within 90 days or you have no lien rights whatsoever. And what counts for the 90 days? So punch list work typically counts, warranty work doesn't. So if you are, doing your final punch, demobilizing, whenever you're stop doing actual work on the property. But if you are done and you get a call and you gotta come back and fix something, that typically does not count. So John, I have a question for you.
Okay.
So this is a question I get a lot and I never quite know how to answer. So I sometimes get clients that say, hey, my sub doesn't want me to file a lien. They want me to come back and do more work to extend the 90 days. I always say that sounds shady. Don't do it. What do you think?
It depends on how aggressive you want to be, because if there is actually work that was not completed, where, you can ultimately, where this ends up is you're in a courtroom. I mean, if you have to file a lawsuit to foreclose a construction lien, you're gonna be under oath on the witness stand in a courtroom. If you can say, subject to penalty of perjury, there was work that was not done, it was under our scope, we went back and did it, then that's the day that you last do that, that's when the 90-day clock starts running. If somebody says, hey, it's been like 100 days, but what do you think, you guys maybe come out and I don't know, fix this light fixture? Well, think about it. Do you want to be on the witness stand in a courtroom saying, well, yeah, that was actually, the project wasn't done. We went back out to complete it. I mean, most people would say, yeah, I'm not gonna risk, 15 years in prison for that. But if you can legitimately say there's work that wasn't completed, then absolutely go back out, do the work, and that's gonna start that 90-day clock running again. So
Yeah.
it totally depends on the circumstances. There's not like a magic yes or no answer on that, but there are ways to restart that clock if there's truly work that needs to be done.
And if you're working with somebody you trust a lot,
Exactly.
you would have to be.
Right.
So it does have to be served by certified mail, and usually, put the little certified mail numbers right in the proof of service. And it has to be served on the owner and the lessee and the general owner or lessee and the general within 15 days of recording. So we usually serve it before it goes out. Hey, we're gonna record this. We serve it after it's recorded. So, yeah, again, allow some time. Not all counties do electronic recording in Michigan, so sometimes that means somebody's got to drive up. Like we've got a project in Roscommon right now, and they don't do e-recording, so somebody had to drive up to Roscommon to file it.
Or they do, but they don't publish it, and so we had to drive up the first time, and then someone in our office was like, I know the secret website, and
Yeah, I forgot about that.
Yeah.
They have a secret e-recording website that's not available through their county. Super fun stuff.
This is, I'm again showing how old I am, but back in the mid 1990s, it was Central Ceiling that filed the lawsuit that went up to the Michigan Supreme Court, because they were doing some work in Wayne County, and what they found out was, they were pretty aggressive or very timely on getting their claim of lien drafted and submitted. But the Wayne County Register of Deeds would take like 100 days to record it.
Which it
would
still
sit-
does, by the way.
Yeah, I know, it would like sit in somebody's inbox for more than the 90 days.
Yeah.
And it would get recorded after the lien rights had expired. And this was, when the case went up to the Supreme Court, the argument was, look, the contractor did everything they were supposed to do. And it was the government that, the government ineptitude that, caused the lien to be untimely. But so, that's, it's gotten a lot better with electronic recording and I think the Supreme Court kind of slapped the wrist of some of the counties that were not staffing their offices appropriately. But that's another reason to get out in front of this and get that stuff in early so that you're not waiting till the last minute, because if that, lands on the Register of Deeds desk and it doesn't get recorded for a few days, that 90 days is a like magic number. Doesn't get recorded, it's not timely, and you don't have a lien.
And as the person on the front line, I can add to that I do the exact same claim of lien every time, and I'd say 40% of the time it gets kicked back and we have no idea why.
Right.
And the county
They all
clerk
have
says, well, figure it out. We're like looking, we're like, oh, okay, well, it's like a whole like murder mystery all of a sudden, trying to figure out why that clerk in that county has rejected it when they accepted the two exactly the same 2 weeks ago. And so that takes some time, it's like a team effort to fit. And I've had it, I think my max was like 7 times they rejected a release as well. I'm like, just release the lien, please.
Releases are even harder to get.
Yeah. Yeah. Those county clerks have a lot of power.
Yeah, I think it's malicious compliance maybe from the case that John is citing.
Yeah. So after the claim of lien is recorded, the claimant has 1 year to file suit. That is another magic number. That's not subject to the substantial compliance standard. If you don't file within 1 year, your lien is evaporated and ceases to exist. Once you do file the lien foreclosure action, hopefully you're using an attorney to do this and they worry about this for you, but you file what's called a notice of lis pendens, which is a notice that appears if they were to do the title work to say there's pending litigation over this property. This can be powerful if the owner wants to get the property sold. They want to clear that lien because they're not going to be able to sell it without selling it subject to the lien.
I have a couple of tidbits. If you do get to this point and hopefully you have a lawyer and hopefully you don't need to get to this point, but a couple of things that I think have surprised certain clients in the cases that I've done is because it's an equitable remedy. You don't have a jury trial. You can also, there's cross claims and counterclaims. So if you've done everything right, just having your lien recorded and somebody else starts a lawsuit, like you can bring it in later. At the end of litigation, say it goes all the way to trial, what you get is, a judgment, a piece of paper. So there's more steps, I think, to do after that. Sometimes people are surprised. We don't normally take cases all the way to trial. There's kind of a choose your own adventure once the complaint is filed. And typically what you'll see is, early settlement at some point during litigation. I've been seeing more offers of judgment in some construction cases where you'll get a formal settlement offer. You can accept or reject it, but then you get into this whole math, situation, because if you reject, you have to do better than the offer. Otherwise, you could pay for the other side's costs and attorney's fees from that point after. So there's a bit of gambling going on there. There's also facilitation, mediation, and case evaluation, which is very similar, but a panel. Dispositive motions where you get all the way through your discovery and then you file a motion to end the case before trial, and last is trial. And I would say probably all of the first 4 or 5 are way more common than even, the big motions at the end, and certainly not trial. So expect all of that. Hopefully don't expect all of that.
Yeah, and because most people, they don't really want the property to be sold, right? They just want to get paid, and it's just using the leverage to get paid.
And I think one of the takeaways is your odds of an early resolution that doesn't cost you as much money to litigate are much better if you have complied with all of the requirements that construction have. So if you have a good lien that the owner or somebody else isn't going to be able to cannibalize you and tip over your lien, you have a much higher probability of getting paid more money sooner.
Who has priority? All construction liens on a project have equal priority. So if it were to go to foreclosure proceedings, everybody would get paid pro rata in accordance with their lien. Construction liens are subject only to interests that are recorded with the Register of Deeds prior to that first actual physical improvement. So that's where that becomes important. If you've got a mortgage on the property that wasn't recorded before the first actual physical improvement, you have a chance to prime the mortgage. It doesn't happen that often, but occasionally it does, and then us lawyers get real excited about it. So
but this is a great, I think that this helps illustrate this principle. You guys know the soccer dome over in Auburn?
Oh, yeah.
Anybody work on that? All right. Well, so that construction project was a mess. And I think there were like about $1.5 million worth of construction liens. There was a $1.1 million mortgage. And when it all came apart, the property it had appraised at about $900,000. There's not enough money to go around. Either the construction liens are getting paid or the mortgage is getting paid, and somebody's out of luck. So what happened was the mortgage had gotten recorded after the excavation started. So this was kind of funny. Like when everybody, all the contractors are trying to cannibalize each other. And like I think it was the HVAC contractor, was arguing that the excavator didn't have a good lien, because they're like, well, if we can get rid of their $400,000 lien, there's more money for us. Well, then they realized, there's that mortgage that got recorded before before the HVAC contractor was on site. All the contractors needed the excavator, because the excavator was moving dirt before the mortgage got recorded. So all of the construction liens, no matter when the work was done, had priority over the mortgage. Now all of a sudden the excavator is the hero, and so the mortgage was behind all the construction. All the contractors got paid 100 cents on the dollar on that project, plus interest, plus attorney's fees, which I can tell you in 33 years has happened exactly one time. That was the only time I've ever seen everybody get paid and the mortgage just got rinsed out. So you don't see it go that far that often, but if everybody's protecting their lien rights, the act is designed to protect the contractors.
Yeah.
Lien rights.
we're getting kind of short on time here.
Yeah,
so let's move a little bit.
Tell
Yeah, we
stories.
already talked about this. Common mistakes. Failure to record a notice of commencement if you're the owner. I don't think I actually explicitly mentioned, if you don't file a notice of commencement then the notice of furnishing is due 20 days after you record the notice of commencement. So basically, if you don't do it for the entire duration of the project as an owner, that indefinitely extends the deadline for your subs to serve that notice of furnishing and file a claim of lien. So if there is no notice of commencement, often we do it as one package. Here's a notice of furnishing, here's a claim of lien. We have our lien now because you did.
Is there a penalty for not filing a notice of commencement?
I don't think so. I think you are responsible for costs that your contractor or subcontractor incurs in finding the information required. So for example, if they had to do title work or something to find the legal description, you might be liable for that. But in practice, I don't see that happening very often.
Cause I probably fill up 90% of ours for our customers, nobody knows how to fill it
Yeah.
out, so.
Yeah, there's not a penalty for not doing it, but it does extend the notice of furnishing deadline for all of it.
Yeah.
The furnishing you said is 20 days.
Right.
How
20
rigid
days
is
after
that?
First
From
filing
your
labor
first furnish.
materials.
Yeah.
It is, the deadline is rigid, but there are ways around it if the owner had noticed that you were working on the project in some other way. As a sub. So say you showed up on site, you said like, hey, John, I'm coming to work on your house, and you have a conversation like, I'm for, you know, A and B excavating.
And your truck is outside and I
Yeah.
see it every day, but I don't get a notice of furnishing for like 3 months. I can't say, well, I didn't know they weren't there. I didn't know they were furnishing on the project. Well, of course I knew, because I saw the trucks, I talked to you.
I think overall, do it within 20 days, normalize it.
Right.
Right? If you haven't done that, not all hope is lost. If I were you, I would forget the exceptions, but remember that there are exceptions and come get a lawyer if you need to use one of the exceptions.
Exactly. Don't have it prevent you from calling an attorney, because there might be something we can do. Again, those strict deadlines, the 90 days, the 1 year, those are the ones you definitely need to remember. Most of the time when we get something too late or very close to too late, it's because, oh, we were trying to work it out. They told us we were gonna get paid. You know, they were just waiting on payment from the owner, blah, 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 blah. If you file a lien, you can always work things later. You can frame it however we want. We have a very nice, we can massage the letter to say, hey, we're really sorry to do this, but we have to do what we need to do to protect our rights. We expect that we'll be able to reach a mutually acceptable resolution, blah, blah, blah. But protect yourself now. You can have more than one lien on the same project. I see this sometimes if you have a suspension in the middle of the project for whatever reason. Maybe you have a lot of bad weather and you're afraid that you might be off the project for 90 days. You could just file a lien now and then file another one later. That's totally fine. That's a little bit different from the situation that we talked about earlier where they want you to come back. You want to make sure that it's all, covered under an agreement and you're not adding extra scope. There are some contracts we will see from time to time that say, oh, you're not going to file a lien on this project. You waive your lien rights in advance. Those are not enforceable. They're void against public policy. There are some also contracts I've seen out of state. I've seen contracts that purport to apply another state's lien scheme. Those are typically unenforceable. So if you're working out of state, just be cognizant of that. I think we've talked about this, the remedies of the owner, that the owner can withhold payment. If, say they get a notice of furnishing and then that sub is never included on their sworn statement, they can withhold payment and pay that sub directly. Do we have a slide on? Yeah, I'm gonna skip to this. So say you have a lien and there's a reason why the lien needs to be gone. Maybe you need a draw from a construction loan to get paid. Maybe there's a bank who is mad about that lien being filed. What you can do is go to a surety, typically an insurance company. A lot of them will do these and buy a construction lien replacement bond. And that bond has to be in the amount of twice the amount of the lien to cover your potential rights to interest and attorney's fees and that sort of thing. But that replaces the lien. And so the property is free and clear. it can be sold, whatever needs to happen to the property can happen to the property, but you still have that bond that you can pursue instead of the lien. And you don't have to do this within 1 year. It's actually just the general contract statute of limitations. So you have 6 years, which is kind of nice. But there is some, cost involved with procuring the lien. Or the bond, excuse me.
And there are
Sorry.
pros and cons, so it's a guaranteed source of funds, but then you kind of lose some leverage too, because now you're just straight right up to the money.
Yeah, but if you're worried, if you have a solvency problem where you are worried about the money being there, the bond can solve that problem for you. And yes, we mentioned this in passing several times, but you are entitled to your attorney's fees under the Construction Lien Act if you have a lien that you're foreclosing, so that's really powerful. Even in settlement, I've had cases where, a bunch of cases where we get at least a portion of our fees as part of the settlement. They're not guaranteed, and you're almost certainly never gonna get every dollar that you spent, so be cognizant of that, but it's very, very powerful leverage when you're negotiating as a lien claimant. And then you can sometimes get them as an owner, but only if the lien is garbage. If it's vexatious. All right, questions? You guys have done a good job asking questions or your presentation, so thanks for that. Much more than us just standing up here yakking. All right,
All right.
thank you. Thanks so much.
So we should cheers to DeAndre now. All right. Are you on the same PowerPoint or the different one? Should you have a experience?
All right, so the portion of the program where we discuss comprehensive and well thought out statutes, that has ended. So we're getting to the alphabet soup of labor and employment laws. Okay.
They can see it. Because you have to be connected to the Zoom. So is there any way? Do you mind sending it to Kathy? If I email it, can you throw it up on the screen? Sorry. We're not as tech savvy as we'd like to be. Or we could just send, should we just send the slides later? What? Send the slides later? Okay, so C Geiger, GEIGER at abcgmc.org.
GMC.
Yeah, abcgmc.org.
You can send a slide later.
Oh, okay. Should we plug this back into him? Sorry.
Okay.
Back and forth, DeAndre.
No problem. No problem at all. Okay, so we will get started here. As Emily mentioned, with respect to any questions that you might have, hoping that this can be an interactive process. And so surely you have some of those employment situations that have been nagging you. I'm going to bestow upon this conversation the cloak of privilege. And so, shout them out to me and we can get started here. As I mentioned, my name is DeAndre Harris, and I'm a partner with Warner Norcross Judd, practicing labor and employment law. This is me in life before ESTA, and happy to be with you all today. With respect to, just to set the stage here. So, I was asked to provide you an overview of HR laws, legal developments that are coming down the pike and that have occurred in 2026. I would say at a high level, this is actually a bit of a different pace for HR attorneys in that we're not dealing with a new law or a new set of rules or practices. I think what we're seeing on the legal side of things is just a change of priorities with respect to existing laws. Having said that, we'll cover both Michigan law as well as some developments at the federal level as well. And again, if you have any questions or want to, discuss a specific set of circumstances that you're dealing with, happy to talk through that. We're going to start with all of our favorites, the Earned Sick Time Act, which has been in effect since last year. Just as an overview, the Earned Sick Time Act requires all employers in Michigan to provide some form of earned sick time. I don't know if you caught, but with respect to these slides, we'll definitely make sure that you have a copy of them. And so don't feel the need to have to, jot down everything on the slide here. But Michigan law now requires all employers to provide some form of earned sick time. If you have more than 10 employees, and for purposes of this law, you are now in the big leagues, and so welcome. You have to provide 1 hour of earned sick time for every 30 hours worked. There is no accrual cap, but you can limit the amount of time to be used to 72 hours in any given year. And a year is whatever you decide it is, as long as it's for 12 consecutive months. An employee can use earned sick time for qualifying reasons. Now, this is a very broad bucket of permissible uses, which includes the employee's own serious health injuries or health illnesses or injuries, as well as those related to their family members. Family member has basically no definition in this act. Basically, as long as you are close to someone enough that you deem them to be like family, you can use earned sick time for purposes of their medical reasons. So that college roommate where you bonded over your dirty room and now you're basically brothers, you can use earned sick time for that. For purposes of the Improved Workforce Opportunity Wage Act, that's basically Michigan's FLSA, the Fair Labor Standards Act. The minimum wage did increase to $13.73 this year. On January 1 of next year, the minimum wage will finally increase to $15 an hour. I say finally because this has been the subject, along with ESTA, of litigation for many, many years. In fact, I think we are on our third and final round of the implementation of ESTA and these changes. And so for purposes of Michigan law, at least with respect to the wage and hour aspects of Michigan law, these are the two takeaways or the two big items that we're seeing right now. One issue that we're currently dealing with under ESTA is the impact of ESTA concerning collective bargaining agreements. I'm very happy to talk about this case, particularly with you all, because you may be impacted by it most. And the reason why I say that is because we just saw conclude, well, I say just, but really last summer, the Michigan Court of Claims issued an opinion and litigation where, just to take a step back, Michigan Earned Sick Time Act, the act says that an employee who has employees that are covered by a collective bargaining agreement, if that CBA is in effect as of 2/21/25, then those employees are exempt from being able to earn and use earned sick time, as long as the CBA conflicts with the terms of the act. Our general understanding, and I say our meaning, labor and employment practitioners, HR professionals, at least most that we interact with in the state of Michigan and on the west side of the state as well. Our understanding of conflicting with the act means if you have some sort of paid time off setup in your CBA, and that's PTO or vacation or whatever the case may be, can be used for purposes of sick time, even if it's at an amount or set up in a way that's inconsistent with ESTA, then the CBA conflicts with the act, and the employees whose terms and conditions of employment are governed by the CBA are exempt. The position was also taken by many employers that to the extent there is no PTO policy or vacation or sick time provision in the CBA, silence it conflicts with the act in that there's nothing that says that the employees whose terms and conditions of employment are governed by that CBA can use time off for purposes of illness or other reasons covered by the act. This was a position that was advanced by the National Electrical Contractors Association, and they sued the Labor and Economic Opportunity Department over Leo's position here, because Leo took the position and still takes the position that silence is not a conflict. And so if a PTO or if a CBA does not address at all the provision of paid time off or any sort of paid leave for purposes of sickness and other reasons covered by ESTA, then that silence is not conflict. And those employees who are governed by that CBA are entitled to ESTA as of 2/21/2025. You may have employees, perhaps through some sort of association contract where rather than having some sort of PTO provision or a vacation policy, you merely have a vacation fund where you provide a portion of funds to a bank. And that bank, although it's titled vacation, it actually isn't a paid time off provision. If you're under those if you are in an agreement with that type of setup, I would encourage you to reach out to your Warner attorney so that we can discuss your options, because what the Court of Claims held here is that the Leo's position is correct. Silence is not a conflict for purposes of the act. And if you are merely paying into some sort of fund or a balance or any type of bucket where there is money that is designated towards vacation, but there isn't actually a PTO or a time off process. And so in other words, at the end of the year, we are going to provide X amount of money to employees who are covered by the CBA. But during the year, if you need time off for an unexpected illness like the flu, COVID, whatever the case may be, that time off is not governed or connected to that bank of money. You have a silent CBA for purposes of ESTA. And so the takeaways here are, of course, to review the CBAs that might be applicable for you and your employees. And if they are silent, then we need to consider what steps to take to make sure that you at least have a defensible position that you're providing employees earn sick time. Next thing any questions on that? That was a lot in a very short amount of time. Okay. So we're going to go through some other cases that we've seen come out of Michigan. And this next one deals with contractually shortened limitations periods. Perhaps you have an employment application or you have a handbook acknowledgement that says, even if you are entitled to, say, 3 years to bring a claim for wrongful termination against us based on any dispute that arises out of your employment or your separation, you, employee, agree that you have 180 days to get in court or put it to rest, regardless of what that limitations period provides. That's a standard provision that many employers in Michigan have adopted. That's a standard provision that I've included in clients' handbooks when I'm reviewing them in their employment applications. And just last year, the Michigan Supreme Court said, not so fast. This type of provision is governed by the general set of rules of reasonableness and unconscionability. And so to the extent that this type of provision is offered to an employee on, let's say, a take it or leave it basis, and let's be honest, most employment arrangements are offered on the take it or leave it basis, then that shortened statute of limitations provision isn't going to just be rubber stamped by a court. And currently the rule is courts have to go through this assessment to determine, okay, was there a lack of a meaningful choice? Did this provision shock the conscience? I'm not a litigator. I'm going to let my litigation partners tell you what shock the conscience mean. But in other words, is this a provision that's buried somewhere in a document? And this employee doesn't meaningfully understand what they're getting themselves into. It's a full assessment now that the court has to go through before determining that this provision is actually enforceable. And so to the extent you have, an 180-day provision in your contract, maybe it's not even 180 days. Maybe it's something along the lines of 2 years. As long as there's a provision that says you, employee, are waiving the right to your full period for purposes of bringing a claim, that's going to be an issue that you need to consider. Is this something that we want to maintain just for purposes of austerity? Perhaps even if we know we can't enforce it, we're going to keep it in there just to make sure that employees are timely with respect to the claims that they bring against us. The long and short is there's no longer any guarantee that that type of provision will be upheld in a court of law. Some other court cases that have come down the pike. And so with respect to the Whistleblower Protection Act, that is a state statute that says that an employee who has reported a violation of law or is about to report a violation of law is protected from being subjected to any adverse employment actions on the basis of engaging in that activity. textbook retaliation claims. Historically, it's been the understanding that laws, for purposes of this act, related to statutes. What we have since learned is that laws also apply to common law claims. And so if an employee is alleging that an employer has engaged in negligent or gross negligent behavior, basically unreasonable conduct that has caused some sort of harm, when the employer, of course, had a duty to engage in a reasonable fashion, then those types of claims now also can form the basis of a whistleblower protection act claim.
Would that include ordinary negligence?
With respect to ordinary negligence, it could. It is a common law claim, and as I understand this case, there's no limitation to the types of common law claims that can be brought. What I would say, though, is if there is a statute that is also governing that same type of conduct, then I think an employer has a better case to maintain, even if it is a negligence claim. I'll give you an example. So MIOSHA has an employee discrimination section, and MIOSHA also looks into adverse employment actions that have been taken against employees for engaging in protected activities under the Act. Reporting unsafe conduct, participating in MIOSHA investigations, things of that nature. Through that setup, MIOSHA already has a framework for understanding and assessing whether or not an employer has, one, acted negligently, because we have standards, safety and health laws that govern what negligence is with respect to, say, PPE, for example. Shouldn't say it's very clear, it's clear as mud, but there are standards that identify how employers are supposed to act with respect to safety and health laws. If there is an argument to be made that an employer is engaging negligently, and the subject matter of that claim is based on the provision of PPE, then I think that MIOSHA's safety and health standards can inform whether or not an employer was actually engaging in a negligent manner, because, again, we have a standard that identifies what reasonable is for purposes of that type of claim.
That makes sense. So in this context, like you should fire somebody for reporting safety problems.
No, please don't fire. Going back to when to call your attorney. Call me before you do that, because I could be much more helpful in that situation. Unemployment benefits, this is really just an FYI. The maximum weekly rate for unemployment benefits has increased from $460 to $530 as of the top of this year. And with respect to the types of dependents, that also has increased. And the main takeaway here is really just to monitor the unemployment claims that are coming your way. You also want to make sure that you're monitoring the budget for workforce turnover, especially if you're in a situation where perhaps you work in a seasonal industry, and with respect to the season, a lot of employees just drop off right before the end of the season. I would make sure that you're documenting whether or not those are voluntary terminations or involuntary terminations. Of course, the general principle is that if an employee voluntarily resigns, unless there is good cause attributable to the employer, then a voluntary resignation is going to inevitably result in an employee being disqualified for unemployment benefits. We run into situations, though, where there's a question, well, did he resign or did you fire him? And the supervisor says, well, I told him either, this is what you're going to deal with, or you need to find somewhere else to work. It's like, okay, well, did he resign or did you fire him? And so with respect to documentation, after you have those critical conversations, the documentation is going to be the key to addressing unemployment claims, in my opinion. I think that's the best defense that you can have if an employee is engaging in misconduct, to the extent that we can demonstrate that they were aware that they were intentionally violating or disregarding some company expectation or rule. That hopefully is a documented expectational rule. That'll also give you a good defense for purposes of these claims as well. All right, so let's talk politics. So with respect to what we're seeing coming down the pike, in fact, this is happening in real time. Many commentators and polls are suggesting that, at least at the state level, the state Senate is going to remain blue. I can confirm that is the case now. Just yesterday, there was a special election, and it looks like that the Democrats are holding on to the state Senate by a very small majority, but that is still the case.
There's also chatter that perhaps the state house is going to flip to blue. The reason that this is relevant is because of some of the bills that are currently stalling, just given the makeup of where we are with respect to the legislature. I'm going to go through some of these, and I'm also going to identify what I think you should be doing, even if these bills don't take effect. So the first here is pay transparency. There is a House bill that would require employers to provide wage information for similarly situated employees for up to 3 years if an employee requests that type of information. I know you may be thinking, well, that's confidential, and I want to just dispel that myth for you right now. Wages, information regarding wages is not confidential under Michigan law. An employee does have the ability to discuss their wages with their coworker or any other third party. And just as a matter of principle, the Michigan Payment of Wages and Fringes Benefits Act makes clear that wages are not confidential. That said, with respect to the provision of this type of data, one thing that you want to be concerned about are Equal Pay Act claims. The Equal Pay Act, which is a federal law, but also is implemented under Michigan law as well, basically states that an employer cannot deny or cannot provide lesser pay to an employee on the basis of their sex. Having said that, there are reasons that you might provide employees different types of pay, and those are valid factors to consider, such as the employee's skill set, the employee's length of service with your company, the employee's the employee's experience even beyond your company. Those objective criteria are permissible to consider when you are providing someone a starting rate. Where you run into issues is when there's no real pay audit that has occurred to make sure that, at least with respect to those valid factors, the pay that you are providing employees are consistent with the data that you might rely on if you were subject to defending on the other side of an Equal Pay Act claim. I have a pending charge right now with an employer, and we got into, the data. Basically, the claim is that this employee who was a team lead was not provided the same amount as her male coworker. There's also a wrinkle here that we're going to talk about, but the general basis of it is that she is a woman and her coworker was a male, and she was paid less than him by a few dollars. And so we get into it, we're having conversations with the hiring managers, and we're trying to understand what are the factors that would justify the pay differential, because there is a pay differential. And one of the comments which struck me is, Jim's also just a really good guy. And we're like, well, you're going to need to provide us more information than that, because I don't think that personality characteristics are a valid factor when we're talking about pay differentials. And so what I would be doing, even if this bill does not go into effect, is engaging in some sort of preemptive pay audit to determine how much are we paying our employees who are similarly situated. And when I say similarly situated, that is a loaded term. And so employees who are performing the same job duties, oftentimes these employees may have the same job title. I think you also want to be mindful of whether they are reporting to the same individuals. It's perfectly lawful to have Supervisor A provide a pay framework that is different from Supervisor B. But to the extent you have employees who are reporting to the same folks, or at least going through the same reporting structure, and they also perform similar or the same job duties, that's where we really want to understand what types of factors are we relying on for purposes of their pay. I would also encourage you to engage in this analysis under the guise of attorney-client privilege. And so working with legal counsel when you're going through this process, because in the event that you are creating documents here, unless it is covered by attorney-client privilege, there's no state law that says that this self-assessment is in and of itself a privileged document. In other words, you could be creating discoverable evidence. And if there are findings through this assessment that we really can't explain, even when we're looking at that objective criteria, it's super helpful to be able to rely on communications with counsel when you're before you reach that determination that there are some issues that we need to fix. Okay, so job descriptions. That's another bill, Senate bill, that requires employers with 5 or more employees to create and provide to employees their job descriptions, including the essential functions of their job. This is a task that I would recommend that you do regardless of whether or not this takes effect. And this is because of the ADA. With respect to the Americans with Disabilities Act, which is also implemented under Michigan law through the Persons with Disabilities Civil Rights Act, the ADA requires an employer to engage in an interactive process to determine whether and to what extent you can reasonably accommodate an employee's medical condition or physical limitations. Having said that, though, there's nothing under the ADA that requires an employer to suspend or temporarily lift essential job duties. And I want to be clear, a job description is not a silver bullet to any sort of claim that a set of skills are essential, but it is one crucial piece of evidence that courts will rely on. Within the construction industry, we see this a lot with respect to lifting restrictions. You come to me and you say, well, we got this, doctor's note that says that they can return to work, but they can only lift, or they can't lift no more than 10 pounds. My questions for you are going to be, well, how often do they lift? Do they lift on a daily basis? How much are they lifting during a particular shift? And all of those can be addressed through your job description. All of those questions can be addressed through having an up-to-date job description. And that's going to be one key piece of data that we rely on when we respond to the employee's request for, a lifting restriction. And that's the same for any sort of accommodation where we're determining that there's a particular set of skills that the employer deems essential to the operation of its business and to the performance of that employee's duties. A job description is going to be one strong piece of evidence that you can rely on in connection with those accommodation requests. The last thing that I'll address here, just with respect to some of the Democratic bills, second to last thing, is the test for independent contractors. Right now, under Michigan law, this determination of whether a worker is a contractor, 1099 worker, or an employee, W-2 employee, that is really a multi-factor assessment. It depends on the surrounding facts and circumstances, such as whether and to what extent the contractor or the worker has the ability to control their own schedule. They have flexibility with determining whether and when to accept the work. They have the freedom to engage in the same type of work for other entities. And more often than not, there are some of these factors that an employer can rely on when the employer determines that a worker is a contractor. One of the bills that is currently stalled in the Senate right now is the adoption of the ABC test. This is a test that is in the state of New York, California. A lot of employee-friendly states have adopted this test, and it is incredibly difficult to pass in order for you to demonstrate that someone is a contractor. The employer would have to show that the worker is free from control and direction, which, okay, perhaps we can do that, but also that the worker works outside the usual course of the payer's business. This is a factor right now that really is not all that material to the assessment under Michigan law. But to the extent that let's say you are a plumbing business and you are contracting someone to engage in plumbing, well, you're in an uphill battle under the ABC test. And then the last one is the worker is customarily engaged in an independently established trade, occupation, or business. If you are in a contractor agreement with Joe Schmo, and there's no evidence that Joe Schmo owns his or operates his own LLC or business or whatever the case may be, then under the ABC test, the courts are going to look very closely at whether or not Joe Schmo is actually a contractor. And so this is a test that you definitely want to keep an eye on. I'm not going to encourage you to adopt this assessment, but with respect to what you should be doing right now is really just engaging in strict scrutiny over whether or not you have workers who are contractors and there's a question about whether or not they should be. This is one of those situations where misclassification can have a domino effect. And so you may not only just be dealing with back pay, but under Michigan law, you have an obligation to provide workers' compensation and unemployment benefits to employees. You also now have an obligation to provide earned sick time to employees. There's also tax-related issues concerning our employees and contractors. So the one misclassification can really have a domino effect and spread across multiple obligations to you as an employer. And so what I would say is, to the extent that you have anyone who's on the line, especially if you have a situation where you have someone who was an employee of yours and through a wind down arrangement or just the employee's preference, they are now a contractor, That's going to be a red flag. If you have a situation where the contractor is engaging in the same type of work as your W-2 staff, that's also a situation where you perhaps want to take a closer look at whether or not they truly are a contractor for purposes of Michigan law. And the last thing here I'll address really briefly is just non-competes. Right now, non-competes are subject to a rule of reasonableness under Michigan law. There are various bills that are designed to address whether and to what extent those types of restrictions can be enforced under the law. I don't see, as I understand the current, political appetite in Lansing, I don't see this bill moving forward all that much. But that's a conversation that's occurring right now at the Capitol, and that's something to keep an eye on. All right, so to shift gears here, we're now going to discuss just some general equal employment opportunity laws. Sometimes when I'm speaking to industry groups, I'll get a comment that says, yeah, but this doesn't really happen like in our space. And I want to just encourage you to not to check out during this next section. And one of the reasons why is because the EEOC's strategic enforcement plan. So just for context, this governmental agency, like many federal governmental agencies, they issue a plan that makes clear what their priorities are over the next course of, several years, how they are going to spend their funds and resources and time as it relates to enforcing the acts that fall within the scope of their jurisdiction. The most recent EEOC strategic plan states that the continued underrepresentation of women and workers of color in certain industries, including the construction industry, are areas of particular concern, especially in industries that benefit from substantial federal investment. Now, you may be thinking between 2024 and 2028, there was one big, change in the federal government as it relates to whether the EEOC is still enforcing their strategic plan in this way. Just earlier this year, the EEOC settled a lawsuit with Builders First Source based on claims of age discrimination. And so from what we can tell, headlines may tell a different story about the EEOC and its current priorities, but it seems that the day-to-day regions that are not in the limelight are still enforcing Title VII, the ADA, and the Equal Employment Opportunity laws in a manner that's pretty consistent with what we've seen even under previous administrations at the federal level. So what's happening at the EEOC right now? Just last year, we saw joint guidance from the EEOC and the Department of Justice designed to tackle what the federal government is calling DEI-related discrimination. I would love to give you a definition of what that is. I cannot because from any statute, you won't be able to find that term. But as we understand it, with respect to the enforcement priorities here, to the extent an employer has DEI policies, diversity, equity, and inclusion policies, that are motivated by protected traits or they set quotas. If you have a hiring practice that says we need to hire at least X amount of women per quarter, that, putting aside this agenda here, Title VII, that is going to be prohibited under Title VII of the Civil Rights Act, and that much is clear. With respect to employer resource groups, perhaps you have affinity groups that your employees maintain to discuss, similar situations that they all are bonded by. First generation employees in construction, women in construction, those types of resource groups that you maintain, if they are exclusionary, in other words, if you have to be a woman in order to have access to that resource group, then that is going to be a practice that the current EEOC will deem unlawful. I will say, especially when we're looking at some of the Supreme Court cases, the U.S. Supreme Court cases that have come down the pike recently, this is really fertile ground for a plaintiff's attorney. And the reason why I say that is because an adverse employment action, I'm pretty sure I've used that term a few times now during this presentation. Before last year or the last year or so, an adverse employment action was understood by many courts, HR attorneys, HR professionals. An adverse employment action had to be a material change in an employee's terms and conditions of employment. Stated differently, I could transfer you to a different shift, but as long as I kept your wages and your benefits the same, yes, you've suffered an action with respect to your employment, but it wasn't adverse. The Supreme Court has made clear that there is no materiality element to the term adverse employment action. As long as an employee is worse off because of that action, the employee has the ability to say that they have experienced an adverse employment action for purposes of a discrimination claim. And so going back to the employer resource groups here, perhaps you have an employer resource group where there is a leader of your organization who also happens to belong to the protected category in question. You have a women in construction group, and your CEO is also a woman, and the CEO also attends these meetings pretty frequently. If I am a male, then the prima facie claim of discrimination is I'm excluded from this employer resource group. I don't have the same amount of access to the leaders of my organization because of my exclusion. And that alone is probably going to be enough to get the case in court, even if the male has not suffered any sort of demotion, decrease in pay, change in benefits. The bar is incredibly low to establish an adverse employment action right now. Also, with respect to adverse employment actions, if you are engaging in anti-harassment training and that training pokes a little bit too much fun at certain cultures, then that can be the basis of a claim as well. So we saw this last year in a case out of New York where a white employee alleged that implicit bias training. And so training that deals with quick thinking that you make based on your past lived experiences. It suggests that you're not being intentionally discriminatory, but based on your lived history and your lived experiences, you engage in a certain way. And without taking a step back to think things through, perhaps you are predisposed to think certain things about people, places, people, places, or other aspects of that. And so implicit bias training, the focus was on white culture, white privilege, and there was a repeat negative inference about being white. That was enough because of the fact that it was mandatory to subject the employee to an adverse employment action. Also going to deal with transgender protections as well. So with respect to the transgender protections under the EEOC in 2020, I believe it was the Supreme Court in Bostock that said that Title VII extends to both sexual orientation and gender identity. The court made clear, though, that with respect to bathroom procedures, dress codes, the minutia of the day-to-day work environment, the court was not addressing any of that. The court stated only that with respect to discriminating or failing to hire someone really, or subjecting someone to an adverse employment action because of the fact that because of their sexual orientation or gender identity, that was going to be discriminatory. The EEOC, after this case, tried to fill in the gaps with guidance, and that guidance did go further than the court. It addressed bathroom procedures. It addressed the use of pronouns in the workplace. It addressed dress codes. And what the EEOC said was, to the extent that you have employees who are, for example, intentionally mispronouncing or misusing an employee's chosen pronouns, that could form the basis of a hostile work environment based on the employee's sexual orientation or gender identity. That guidance was struck down by a federal court because the court determined that it exceeded the scope of the holding in Bostock, and so that guidance was rescinded. But also what we saw is after the Trump administration came into office, the current chair of the EEOC, with support from other members of the commission, rescinded the entire guidance as it relates to harassment in its entirety. And so if you look on the EEOC's website right now for any sort of advice or guidance on what harassing conduct may be, you're probably going to see a blue box at the top that says this document has been archived. I want to dispel any sort of myth that means that harassment in the workplace now is fine. Under Michigan law, transgender protections are still called out as an express protected category under the Elliott Larson Civil Rights Act, which is the state counterpart to Title VII. We also have, actually, I'm going to skip this. This deals with the conflict between the religious accommodation request and the use of pronouns in the workplace. But essentially to say there is a tension between employees who perhaps feel as if using another person's pronouns that are inconsistent with the pronouns that that person were assigned at birth, then being required to do that is going to violate their own religious principles and beliefs. This area of the law is clear as mud right now. Under Michigan law, we haven't even seen the Michigan Department of Civil Rights come out and address what an employer's expectations are. I would say keep it simple, to the extent that you have civility or respect work rules in the workplace, then, I would just implement those in a way that's consistent with your organization's culture. Okay, now we're going to turn to the Pregnant Workers Fairness Act. We're really just hitting all of the, dinner table conversations in this presentation. So with respect to the Pregnant Workers Fairness Act, that is a relatively new law that fills the gaps as it relates to pregnancy, childbirth, and related medical conditions. Under the Americans with Disabilities Act, pregnancy in and of itself is not a disability. Now, I'm not saying that. That's what the courts have said. Pregnancy in and of itself is not a disability. And so what the PWFA does is fills in the gaps. And so to the extent an employee does require some sort of accommodation because of their pregnancy, childbirth, or related medical condition, then the PWFA says that the employer has a responsibility similar to the responsibility under the ADA to engage in an interactive process and determine whether and to what extent the employee can be reasonably accommodated. Two areas where the PWFA goes further than the ADA is essential functions. I told you at the top of this presentation, the ADA does not require an employer to suspend or eliminate essential functions. The PWFA does, to the extent that it does not amount to an undue hardship. Specifically, to the extent that the essential function can be limited or suspended for 40 weeks or less, then you have an uphill battle of showing that that essential function amounts to an undue hardship. And that 40 weeks is tied to the amount of time it takes for an employee to give birth. Second area is with respect to abortions. And so the guidance or the regulations that were issued under the PWFA suggested that an employer did have to accommodate an employee's elective abortion. This case that was just issued last year, that part of the regulation has been overruled, and so an employer no longer has that responsibility at the federal level. In Michigan, the Elliott Larson Civil Rights Act still allows for an employee to be protected from an adverse employment action if the adverse employment action is on the basis of the employee electing to have an abortion. Okay, some lighter topics with respect to the disparate impact. And so Title VII covers two types of discrimination. Intentional discrimination, of course, where an employer is intentionally engaging in some sort of conduct because of the employee's protected category. There is also another framework for a discrimination claim to be elevated or maintained, and that is through disparate impact. And so perhaps you have a facially neutral policy that impacts a certain group of employees more than it impacts others. For example, if you have a hiring practice that says we're only going to hire individuals who have a consistent employment history and there's no breaks, well, if you have stay-at-home moms or stay-at-home parents generally, then that's going to be the basis, or it could be the basis of a disparate impact claim. Even though you are not intentionally engaging in any sort of hiring practice to make stay-at-home parents worse off, that type of facially neutral policy or practice could result in discriminatory treatment, even if it's not intentional. The EEOC has stopped investigating these types of claims. And so after October 31 of last year, more likely than not, you probably haven't had any employees. And I would also even say before October 31, I haven't received a ton. I probably haven't seen any disparate impact EEOC charges, but the EEOC has made clear that that's no longer a priority. However, this principle still exists for purposes of private litigation. And so plaintiffs' attorneys are probably now feeling more empowered to go after these types of cases, recognizing that the EEOC doesn't address them anymore. And so while this is no longer an enforcement at the federal government, the principle still applies in case law. AI is a topic that we can spend the rest of this 15 minutes going over. So what I'll just say here is really with respect to the use of AI, especially if you are using it to hire or assess employees, that you want to make sure that with respect to whatever vendor you have, there's clear indemnification language in the event that you are sued because of a decision that was made by that software. We saw this a lot with ZipRecruiter and other types of online platforms that employers use, where through the algorithm, certain employees have been screened out, perhaps because of their geographic ties or something on their resume that just suggests that they're not qualified for the position. In the event that that algorithm develops a systemic bias against certain applicants, this can and has formed the basis of failure to hire claims. And you want to make sure that if you're relying on this type of software, again, we're clear with the vendor that if we're sued because of this algorithm, you recognize that you're picking up the tab vendor. Harassment by third parties. And so here this is actually a change in what we've seen historically. The Sixth Circuit, which, as I understand now, this decision is not going to be changed because the Supreme Court has decided they're not going to deal with the circuit split. But the Sixth Circuit has broke with other federal circuits with respect to harassment. It's been a common understanding that an employee who is subjected to harassment by a third party, a customer, a visitor on the site, an intern, someone who is not an employee employed by the organization, that type of conduct can still form the basis of a hostile work environment claim, especially if the employer doesn't take steps to prevent that type of conduct from recurring. The Sixth Circuit came out with the decision last August that makes clear that unless the employer intentionally designed for the harassment to occur, the employer is not going to be responsible for the conduct of a third party. You will not find another federal circuit out there that agrees with the Sixth Circuit on this case. But as I said, I believe it was last month, the Supreme Court denied cert, which basically means that they denied to take up a case that would have resolved the split between the Sixth Circuit and other circuit courts as well. And so now, for the foreseeable future in Michigan and other states that are within this federal jurisdiction, this is the law of the land as it relates to third-party harassment. Having said that, Michigan Department of Civil Rights also investigates harassment in the workplace by third parties. I don't see the MDCR adopting this approach. And so you want to exercise caution when you're dealing with harassment claims where the claim is that the conduct occurred outside the workforce. I think it would be prudent to still investigate that conduct and determine, what action we can take in order to stop it from occurring. But as the slide says, you want to keep this case in your back pocket just in case. I am going to skip ahead here because of time, but I do want to address the FMLA and the ADA. And what I'll do is I'll just say, to the extent that you have some sort of attendance practice, and I don't know how your attendance practice is set up. Perhaps you have the employee text you or text someone to let them know that they're not coming in. If you are covered by the FMLA, meaning you have 50 or more employees, then you want to make sure that whoever is on the receiving end of those texts or those communications know enough about the FMLA to know when it's possible that we may be dealing with a situation where the employee is seeking time off that's covered by the FMLA. In this case, what we saw is the driver who had sickle cell told the employer that he needed to go to the hospital because he needed to go to the hospital and he had no babysitter. If an employee has to go to the hospital, my ears are tingling to understand whether or not we're dealing with the FMLA claim. But on the attendance record, what was logged is the employee could not come in because they had no babysitter. Not having a babysitter is not a protected activity, or it's not a protected reason for time off under the federal FMLA, or really under ESTA either, unless there's some sort of school closure or the child is quarantined. And so based on this points-based system, the employee was let go. But once you dig into the facts, it became clear that the employee actually was taking time off to go to the hospital and not because of the lack of a babysitter. And based on that situation, the termination was enough to allow the employee to maintain an FMLA claim because of the fact that the documentation didn't make clear that the employee was actually seeking time off under the FMLA. Another situation we see with respect to the FMLA is where the employee provides a certification form where there is an estimate of how many days off the employee is going to need for their serious health condition and how long that time off is going to last. And I will say, I think there are employees out there that know the FMLA better than I do, and they figured out how to really work the system. And so you typically see the situation where an employee who knows that the writing is on the wall for performance or conduct or whatever the case may be, and to shield that inevitable termination of employment, they go out and get certified for FMLA leave. This is a case where I'm assuming this is a situation that happened. The facts don't really get into it, but you've seen these cases enough to know that that's exactly what happened. The employee had a certification form. The certification form provided for a certain amount of estimates. And the moment that the employee took time off that was more than what the estimate provided, the employer terminated the employee's employment. And because an estimate is just that, it is an estimate, it's not a hard cap, the employee alleged that the termination violated the FMLA, and the Sixth Circuit agreed. And so the proper action that you want to be considering here, the FMLA makes clear that to the extent an employee is taking time off that's inconsistent with the certification form or gives you as the employer, reason to believe that there is a need for an updated certification form, and this is definitely a reason to believe that there's a need for an updated form, then you just send the employee back to the provider to get an updated form. Termination before going through that process is probably, it is going to be a very risky move. Leave for travel time. Essentially, the Department of Labor has issued an opinion letter that makes clear that an employee's travel in connection with their need for FMLA leave is also going to count towards their FMLA time, which I think is really a good thing because it gives the employer the ability to burn down that 12 weeks at a faster pace. All right, I want to talk about the FLSA and then just give you time for questions to the extent that you have them. The most pressing thing that we are seeing under the Fair Labor Standards Act right now relates to the calculation of overtime. The FLSA is clear in that if an employee is not exempt from overtime or minimum wage purposes, in the event that the employee works more than 40 hours in a work week, the employer has to provide time and a half. One area where plaintiffs' attorneys are having great success at is the calculation of that regular rate of pay for purposes of that overtime calculation. And the regs are clear as mud in many ways, but one of the ways that they are clear is it makes clear that bonuses, especially non-discretionary bonuses, where if an employee has to achieve a certain type of criteria, attendance, production, whatever the case may be, if that bonus is awarded, then the bonus does need to be calculated into the regular rate of pay. In other words, if the employee earns $15 an hour and they also are eligible and they receive, a perfect attendance bonus, if you're relying on only that $15 an hour to determine how much overtime they are entitled to, if they work more than 40 hours a week around the same work period where they receive the bonus, you violated the FLSA because you haven't taken into account that perfect attendance bonus as well. This is a situation that is prime for collective actions. We've seen a lot of big employers be hit within the last year or so for purposes of this issue exactly. And so another area where you should be auditing your pay practices, especially in connection with counsel, is looking at, okay, do we have any bonuses or any sort of incentive pay that falls within the scope of the regular rate calculation? And if so, are we taking appropriate steps to make sure that we're paying employees what they're actually entitled to? Because even if you have a situation where we're looking at, okay, every employee is entitled to just pennies on the dollar, to the extent that we're talking about a large group, that's going to be enough to attract a plaintiff's attorney. I know that you've already had a lot of union avoidance topics, and so I'm not going to spend a ton of time here, other than to say one of the issues that I come across in my practice is occupational safety and health issues. Safety is one of the number one reasons that employees look to unionize, and so with respect to the Michigan Occupational Safety and Health Act, in the event that you are running into situations where you have employees that are frequent flyers with MIOSHA, that's going to be a situation where you want to make sure that you are keeping your ear to the ground to understand whether or not any organizing activity is occurring. And since I have a captive audience, especially a captive audience in your industry, it's good for me to also say one of the common issues that I'm seeing in my practice is employers who perhaps are subcontractors or higher tiered subcontractors on a work site, and they're getting citations from conduct that occurs with by employees that you don't employ. If I had a dollar for every time I explained the controlling employer principle to an employer in the construction industry, I think my daughter would be able to go to college, without any sort of loans. And so what I would recommend that you do is if you have any sort of service agreements or agreements with other subcontractors or contractors generally, you want to understand who's agreeing to safety and what your safety obligations are through that contract. In addition, perhaps you have a contract that says you, subcontractor, assume all responsibility for the safety of your employees when they're on the job site. If you have, and that is fine, but if you become aware of conduct that is unsafe on the job site and you don't take reasonable action to make sure that it is addressed, you also can still be cited for that conduct if MIOSHA shows up. And so to the extent that you have any sort of foremen that are on the job site watching the employee work without fall protection or watching them work without proper PPE, and there's no follow-up with the contractor after the fact to say, saw this today at the site, want to make sure that you address it, you could still be hit by a citation with MIOSHA, even despite, your contract language that says we're not responsible. With that, I'm going to turn it over to John. Unless there are any questions.
So AAP contract came up and getting mixed information. So if it was the requirement of having the DPI language in the AAP for a federal contract rescinded, because I see yes and then I see no, and so it's like I'm going back and forth because I have to ensure if it wasn't rescinded that I'm putting the DPI language within this contract, this AAP.
Yeah, and I have to be incredibly honest. I don't even know where that stands today because at one point it was rescinded, and I'm not familiar with where that litigation stands as it is today. But I have my card, and we can definitely connect after the fact.
I'll just make a piggyback on your last comment. If you do have like bare bone contract agreements, the safety thing is a really good reason to flesh that out a little bit and make your safety obligation really clear.
So, question comes up quite a bit when it comes to aging employees. Guys that are truck drivers, guys that are doing pretty dangerous work, but are still relatively healthy, still passing their semi-annual tests. But at what point does the employer both have the obligation, but also the right to gently retire someone?
I will say you have an obligation to act where there is, and I want to be clear, based on the what you described, I wouldn't consider this a direct threat, but where you see conduct that can amount to a direct threat under the Americans with Disabilities Act. In other words, conduct that places either the employee or someone else at serious risk of harm. You have the right to have that employee go through an independent medical evaluation to determine whether and to what extent they can still perform their essential job duties, with or without accommodation. That doesn't mean you have the right to exit them, but to the extent that you do receive information from the provider that says, yeah, this person shouldn't be on the job, that is going to be a much more defensible termination than not going through that process. In fact, I believe there's a case
You see a
here.
lot of times, 75-year-old truck driver, right? Guys who've been for 40 years.
Yeah.
Won't retire, and they go the old, this guy's gonna die in this truck. Well, we don't want him to, and but he doesn't want to leave.
One of the, my personal opinion is one of the greatest shortcomings of the ADA is that it is reactionary only. Meaning you have to wait until some conduct has occurred to suggest that, okay, perhaps this person shouldn't be in this position. The moment that you become proactive, you walk right into a potential discrimination claim, even if you have the best of intentions. Now, to the extent that you have a one-off conversation with an employee, the case law is clear. You are meeting as part of your annual evaluation, and you just want to better understand, okay, how many years of service do you have? Are you thinking that limited inquiry without pestering? That might be enough. That might be fine to, to engage in that limited type of questioning. But if you are saying, I'm just really concerned, just getting up there, perhaps it's best for everyone to just gently tell them to, hang it up. You're going to walk into an age discrimination claim.
Is that why you keep asking me how many years?
John, you weren't supposed to bring up yesterday's conversation. Yeah. That's a great question though. And it's a delicate one too, especially when you have someone who is not ready to hang it up, or can't for financial reasons perhaps. But unless we're looking at conduct that places their safety or someone else's safety or health at risk, it's a tightrope to really walk.
Well written though. What about mandatory retirement age? You get away with that?
Before I go there, so like written, safety violations, I would say that that's just that doesn't even take into account age. If you are subject to progressive discipline, you have a progressive discipline policy, and
Even though age, they call it.
yeah. As long as we are consistent in our application, I think that that's a defensible position. Mandatory retirement ages, that's a unique beast in and of itself because we're dealing with employee benefits and ERISA. It's not my practice area, but concerning the mandatory retirement age, I don't see any exception to that, right? I think you walk into a problem to the extent that you're doing it only for older employees. And so perhaps you have a mandatory retirement situation where, after 20 years of service, you're done. And under those circumstances, you can have younger employees that are also retired as well. But if we're basing it on the retirement age, and I want to be clear, this is where I think I'm getting outside of my wheelhouse, that's going to be a more nuanced assessment that takes into account employee benefits.
Mandatory retirement for some employers.
Yeah.
I don't know how they get away with it.
I would not be shocked if that's a unique industry specific requirement.
Or maybe truck driver.
Yeah. Okay.
Appreciate it.
Yeah. Thank you all.
Yeah, sorry, John.
Thank you.
Being here. If you have any questions, be here for a minute while we wrap up. Thank you guys so much.
Thank you.
Thank you.
Thank you.
Thank you.
Yeah.